moving on, we are going to learn about the implied terms in the hire purchase agreement. So number one, acquired possessions. Before I start with these discussions on the acquired possessions, what is implied terms? Okay, implied terms, as what we have discussed in our lectures, is more like a common sense. Okay, something that has been expected by the party to the contract, even though it is not explicitly stated in the contract, but the party is expected for such a terms, and it is being understood as well. Okay, so number one is the quiet possession. So according to section 7(1)(a), there is an implied warranty that the hirer has the right to enjoy the quiet possessions of the goods without the interference from the owner, okay, the seller, or third party claiming the rights over the goods. So we have a two case reference here, Jones versus Levington. The court held that there should be no interference by the seller or anyone acting through the seller. Okay, and Niblett versus Confectionery Materials Co. The court said interference with possession does not have to mean someone physically takes the goods away. It could be a legal claim by a third party that could disturb the buyer's quiet possessions. Okay, the interesting about this Niblett versus Confectionery Materials Co. It's about a company that actually manufactured a milk product, and it is referred as a Nisi. And then there is another company called Nestle. I'm sure you know about the Nestle. So this Nestle is actually claiming, okay, trademark disputes, saying that this Nisi is similar to the Nestle, and it could actually confuse the consumers in the market, some things like that. Okay, so this case actually shows that it does not mean that people can snatch your goods, physically takes the goods away, but it also means that there are legal claims that will push the hirer into a very confusing situations or maybe disturbing situations. Okay, number two is the title. This is accorded under section 7(1)(b). There is an implied condition that the owner has the legal right to sell the goods when the ownership is passed to the hirer. Okay, so we have this Ahmad Ismail versus Malayan Motor Co. A car detained by the police was later confirmed not stolen. The court held that the owner had the right to sell it. Okay, and number three, goods free from the charges or encumbrance, section 7(1)(c). The goods must be free from charges, debt, or encumbrance in favor of third parties when ownership passes to the hirer. We have this Tenki versus Edwards, where the hirer successfully claimed against the owner for failing to settle the tax imposed on the car. Okay, and then you have this merchantable quality. This one sounds like from the Sale of Goods Act, section 7(2). Okay, there is an implied condition that the goods supplied are of merchantable quality, meaning they are reasonably fit for the normal use, unless, okay, exceptions rule is that this condition does not apply when the hirer examined the goods and should have discovered the defect. Okay, they already know there's something wrong about the goods. Okay, number two, the goods are second-hand goods and the agreement clearly states so, and the warranty regarding the quality and fitness are excluded with the hirer written acknowledgement. Okay, so if these two happen, they can't actually go and claim for this the good supplies are not merchantable quality. So we have this case reference Lauthitia versus Hargill Engineering, Sir Berhard others. The defect in the machine was not visible during inspection, so the owner remained liable. Okay, so even in the short period of time, okay, even though during the first inspection it's not obvious, but after during the usage something happened, the owner is still liable.